Thank you for listening. This course was created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional podcasts, books, newsletters, and cool merchandise await. Let's get started. Policy awareness is often overlooked by practitioners who feel that law is someone else's domain, best left to compliance officers or legal counsel. Yet, misunderstanding the basics can itself be a major source of risk. Developers who are unaware of privacy requirements may inadvertently design systems that violate them. Business leaders who misunderstand liability rules may expose their organizations to costly lawsuits. The purpose of this episode is not to turn listeners into lawyers, but to equip them with plain language guidance that helps them recognize where risks might arise and when expert advice is needed. Policy knowledge serves as a compass, pointing practitioners towards safer choices and away from unnecessary hazards. By positioning policy awareness as part of responsible AI practice, we acknowledge that governance is not just external regulation, but also internal literacy about the rules shaping the landscape. Privacy regulation is perhaps the most visible area of policy affecting AI today. The European Union's General Data Protection Regulation, often abbreviated as GDPR, serves as a global benchmark, influencing laws far beyond Europe. It emphasizes consent, the right to deletion, and protections around cross-border data transfers. In the United States, the California Consumer Privacy Act has emerged as a leading example, granting consumers rights to know, delete, and opt out of certain data practices. For AI practitioners, these rules shape how data can be collected, stored, and processed. Violations are not only costly in terms of fines but also erode user trust. Understanding these regulations in broad strokes helps practitioners design systems that respect individual rights, even before lawyers translate requirements into detailed compliance programs. Consumer protection laws add another layer, focusing on fairness and honesty in the marketplace. These laws prohibit unfair or deceptive practices, setting standards for truth in advertising and product claims. For AI-powered services, this means that promises made about capabilities must be accurate and not misleading. A chatbot advertised as secure must not expose user data through sloppy implementation. Enforcement by consumer protection agencies ensures that organizations cannot exaggerate or misrepresent what AI tools can do. This is particularly important as hype around AI creates pressure to overstate benefits. Awareness of consumer protection obligations encourages practitioners to communicate capabilities responsibly, grounding ambition in evidence rather than marketing spin. Such caution helps avoid not only regulatory enforcement, but also reputational harm. Product liability concepts take the discussion into the realm of responsibility for harm. If an AI system causes damage, whether financial, physical, or psychological, the question becomes who is liable. Traditional frameworks distinguish between strict liability, where manufacturers are responsible regardless of negligence, and negligence-based liability, where failure to exercise reasonable care is the standard. For AI, these debates remain unsettled, but the implications are clear. Developers, deployers, and even insurers must consider how responsibility is distributed. Increasingly, organizations are exploring insurance coverage tailored to AI risks, recognizing that liability is not hypothetical, but real. Understanding product liability helps non-lawyers see why careful testing, documentation, and transparency are not just good practices but protective measures, shielding both users and organizations from cascading harm. Employment and civil rights law is particularly relevant as AI enters the workplace. Hiring tools that rely on algorithms face scrutiny under non-discrimination mandates, which prohibit bias based on race, gender, or other protected categories. Equal opportunity obligations extend to workplace evaluations and promotions as well. Lawsuits have already driven organizational change, pushing companies to re-examine datasets, features, and evaluation metrics. The risks here are not abstract. They directly affect people's livelihoods and dignity. For practitioners, this means designing with fairness in mind and anticipating how outputs might reinforce or disrupt existing inequalities. Civil rights frameworks remind us that responsibility is not just technical but moral, requiring vigilance against perpetuating discrimination under the guise of efficiency. Sector-specific rules further complicate the picture, as different industries impose unique obligations. In healthcare, the Health Insurance Portability and Accountability Act governs the handling of patient information, demanding strict privacy and security controls. Financial institutions must comply with anti-discrimination laws in lending, ensuring credit scoring models do not disadvantage minority groups. In education, student privacy laws protect sensitive records from misuse in digital tools. Law enforcement agencies operate under oversight frameworks designed to protect civil liberties when deploying AI-driven surveillance or predictive policing. Each sector brings its own mix of legal requirements, and practitioners working in these spaces must be attuned to the specific rules that shape their systems. These frameworks show that responsibility is not uniform but contextual, reflecting the high stakes of particular domains. Global variations in policy reveal just how diverse the regulatory landscape is. In the European Union, the emphasis is on rights and dignity, with frameworks like GDPR and the forthcoming AI Act prioritizing individual protections. Asia-Pacific countries often seek a balance, promoting growth and innovation while layering in selective regulation to protect public interests. The United States takes a fragmented approach, relying on sectoral rules rather than comprehensive federal legislation, leaving gaps that states or agencies sometimes attempt to fill. For multinational organizations, this patchwork means that compliance cannot be a one-size-fits-all exercise. Instead, they must develop multinational strategies that adapt to local rules while maintaining consistent commitments to fairness and accountability. For non-lawyers, the key lesson is that policy awareness must include a global lens. What is permissible in one jurisdiction may be prohibited in another. Despite the diversity of regulations, some key themes recur across laws. Transparency appears repeatedly, whether in privacy disclosures, advertising claims, or consumer protections. Data minimization is another common requirement, limiting the collection and retention of personal data to only what is necessary. Fairness in access to services is a central concern, especially in finance, healthcare, and employment. Accountability structures, such as mandated documentation or clear lines of liability, appear across multiple frameworks. Recognizing these recurring themes can help non-lawyers identify red flags even without legal expertise. If a system lacks transparency, collects excessive data, or shows signs of unfair treatment, it likely intersects with policy obligations. These themes form the connective tissue of responsible practice, guiding practitioners towards safer design and operation. Facial recognition offers a vivid case example of how policy concerns translate into real-world restrictions. Some cities have banned its use entirely, citing civil rights risks, while others have placed moratoriums in specific sectors such as law enforcement. Advocacy groups have filed lawsuits arguing that facial recognition violates privacy and equal protection rights. These legal and social pressures have reshaped vendor markets, with some companies withdrawing or scaling back their offerings. The lesson is that public concern, combined with legal action, can materially change how technologies are developed and deployed. For practitioners, facial recognition illustrates how failing to anticipate civil rights issues can lead to both legal and market consequences, emphasizing the need for early engagement with ethical and policy considerations. Credit scoring models offer another instructive example. In the United States, the Equal Credit Opportunity Act prohibits discrimination in lending, and regulators have investigated whether algorithmic models comply with this standard. When bias is detected, financial institutions have faced lawsuits, fines, and mandated remediation programs. Increasingly, regulators are pressing for explainable scoring, requiring institutions to provide reasons for decisions that affect applicants' access to credit. These pressures illustrate the intersection of fairness, transparency, and accountability in law. For practitioners, they highlight why fairness metrics, bias testing, and explainability tools are not optional extras but necessary safeguards. Credit scoring models show that policy awareness is not abstract. It directly shapes the architecture, monitoring, and communication strategies of real-world systems. Compliance, though often viewed as a burden, can also be an opportunity. Organizations that are regulation-ready often gain a competitive edge, winning trust from customers and regulators alike. Compliance reduces the risk of litigation and penalties, freeing organizations from costly crises that might otherwise derail projects. In some cases, compliance even opens access to new markets, particularly in jurisdictions with strict requirements. Being able to demonstrate alignment with regulations becomes a mark of credibility, especially in industries where trust is fragile. Seen this way, compliance is not simply about avoiding negatives, but about creating positives: reputational strength, market access, and long-term resilience. For practitioners, this reframing encourages a proactive mindset, seeing compliance not as constraint, but as strategy. Still, challenges of compliance remain real. Overlapping obligations across jurisdictions can create a maze of requirements that is difficult to navigate. Audits and documentation demand resources, and smaller organizations may struggle to meet expectations. Emerging regulations often lack clarity, leaving teams uncertain about how to prepare. There is also the risk that compliance processes, if poorly designed, slow innovation and discourage experimentation. These challenges highlight why policy basics matter even for non-lawyers. Awareness helps practitioners anticipate difficulties and work constructively with legal and compliance teams. Understanding the landscape reduces frustration, as it turns ambiguous demands into structured conversations about trade-offs and priorities. Compliance may be complex, but complexity is more manageable when it is mapped clearly. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. AI is beginning to attract laws written specifically for it, marking a shift from adapting older frameworks to building new ones. The European Union's proposed AI Act is the most advanced, using a risk-based classification to impose stricter obligations on high-risk systems, such as medical devices or law enforcement tools, while easing requirements for lower-risk applications. In the United States, legislative proposals like the Algorithmic Accountability Acts aim to mandate audits and impact assessments for significant AI deployments. National strategies in countries such as Canada, Singapore, and Japan are shaping obligations through a mix of regulation, funding, and guidance. Where gaps remain, industry self-regulation often fills the space, with companies adopting voluntary codes to reassure stakeholders. For non-lawyers, the lesson is clear. AI is entering a phase of targeted regulation, where practitioners must expect growing scrutiny tailored to the unique challenges of machine learning and automation. Not all guidance comes from binding law. Soft law and standards are playing an increasingly important role in shaping responsible AI. Voluntary codes of practice, such as those developed by industry consortia, offer shared principles that organizations can adopt even without legal mandate. International bodies like the International Organization for Standardization and the Institute of Electrical and Electronics Engineers are producing technical standards that define best practices for transparency, fairness, and safety. Academic and civil society groups publish guidelines that often influence regulators and industry alike. Sector initiatives such as healthcare or finance-specific standards are also moving toward harmonization, making it easier for organizations to align practices globally. For practitioners, these softer frameworks provide actionable benchmarks, giving structure to responsibility even in the absence of strict legal enforcement. The role of regulators is also expanding. Existing agencies continue to enforce laws around privacy, discrimination, and consumer protection, but many are now calling for broader AI oversight powers. Regulatory sandboxes have emerged as one response, allowing organizations to test innovations in controlled environments with reduced legal risk. These sandboxes create space for experimentation while still protecting stakeholders, striking a balance between innovation and accountability. Public consultations are another tool regulators use, gathering input from diverse communities to shape future rules. For non-lawyers, the key is recognizing regulators not as distant arbiters, but as active partners whose priorities influence the direction of AI. Engaging constructively with regulators can yield clarity, credibility, and even competitive advantage. Organizations themselves are adapting to these shifts by building dedicated compliance structures. Many now establish AI compliance teams, staffed with both legal and technical experts, to ensure that responsibility is built into the development process. Lawyers are increasingly embedded in product teams, helping developers understand obligations during design rather than after release. Training programs raise awareness across staff, equipping employees with the knowledge to flag potential risks early. Audit-ready documentation is also becoming a norm, as organizations anticipate that regulators or partners will demand evidence of responsible practice. These responses reflect a recognition that compliance is not a separate silo, but an integral part of AI development, requiring coordination across roles and disciplines. Balancing policy and innovation is a recurring concern, particularly for startups and smaller organizations. Some fear that regulatory obligations will stifle experimentation, creating barriers to entry. Yet early compliance can also be an advantage, positioning companies to scale into regulated markets with fewer roadblocks. Sandboxing again serves as a compromise, allowing organizations to innovate within guardrails that reduce the risk of harmful outcomes. Partnerships with regulators provide additional guidance, enabling organizations to navigate requirements more confidently. For practitioners, the lesson is that policy and innovation are not enemies, but partners. Effective compliance clears pathways for sustainable innovation, while reckless disregard for policy often leads to setbacks. Cultural awareness of policy pushes responsibility beyond checklists and audits. When teams understand the principles behind regulations, fairness, transparency, accountability, they begin to see policy as more than external constraint. It becomes an ethical compass that shapes organizational behavior. Proactive approaches encourage teams to anticipate obligations rather than scramble to meet them after the fact. Respect for stakeholder rights becomes ingrained, guiding decisions that extend beyond what is legally required. In this way, policy literacy contributes to culture, aligning organizational values with societal expectations. For non-lawyers, cultural awareness transforms abstract rules into daily practice, helping ensure that compliance is not only met, but embodied. Looking ahead, anticipating future policy shifts is critical for practitioners and organizations alike. Generative AI has already sparked heightened debate, with regulators considering new oversight measures to address issues like misinformation, copyright infringement, and unsafe outputs. Stronger enforcement against biased outcomes is also expected as agencies move from recommendations to penalties. Cross-border harmonization may grow, particularly as international trade and cooperation push for common standards. Public scrutiny, amplified through media and advocacy, will continue to pressure both governments and corporations to act decisively. For non-lawyers, the key takeaway is that the policy environment is not static. It is dynamic and evolving quickly. Staying aware of these shifts provides resilience, allowing organizations to adapt before regulations crystallize into binding obligations. From this discussion, several practical takeaways emerge. First, laws establish baseline obligations, but they are not ceilings. Ethical responsibility often demands more. Second, awareness of policy basics helps prevent costly missteps, whether in data handling, product claims, or workplace fairness. Third, compliance aligns naturally with broader goals like fairness and accountability, making it an enabler rather than a barrier. Finally, policy readiness strengthens organizational resilience, preparing teams to meet challenges with confidence. These takeaways highlight that non-lawyers do not need to master legal codes, but they do need to understand the principles that underpin them. Responsibility is about awareness and application, not memorization of statutes. Building skills for non-lawyers means learning how to engage with policy in accessible ways. Plain language summaries of key regulations provide practical orientation without overwhelming detail. Knowing when to escalate to legal experts is just as important, ensuring that complex questions are handled by specialists. Integrating policy checks into workflows, such as design reviews or pre-deployment audits, brings responsibility into everyday practice. Case studies also serve as valuable training resources, grounding abstract obligations in real-world scenarios. For practitioners, these skills are less about law and more about literacy, the ability to recognize when policy is relevant, how it shapes design, and where to seek guidance. This literacy empowers teams to act responsibly without needing law degrees. The growing importance of governance roles creates opportunities for professionals who can bridge the gap between technical practice and policy awareness. Organizations are increasingly hiring AI-compliant specialists, embedding them in development teams to ensure obligations are met. Risk and ethics teams are expanding, incorporating cross-disciplinary expertise that includes policy literacy. For individuals, developing these skills provides career resilience, opening roles that combine technical insight with governance competence. Cross-disciplinary opportunities are growing, as regulators, corporations, and civil society seek people who can translate between legal frameworks and technical realities. Policy literacy is not only protective, but also enabling, equipping practitioners to lead in an era where governance is inseparable from innovation. As we conclude this episode, let us recap. We explored the purpose of policy awareness and why it matters for non-lawyers, highlighting how misunderstanding can create risk. We reviewed major areas of law privacy, consumer protection, liability, civil rights, and sector-specific rules, while noting global variations and recurring themes. Case examples in facial recognition and credit scoring showed how laws shape real-world outcomes. We also examined compliance as both an obligation and an opportunity, with challenges that organizations must address thoughtfully. Emerging AI-specific laws, soft standards, and regulatory innovations highlight the evolving landscape. Through it all, policy awareness emerged as a critical component of responsible AI practice. Looking forward, our series will dive deeper into regulation and practice, examining how frameworks are implemented and enforced. Policy sets the stage, but the details of execution, how organizations respond, how regulators act, and how stakeholders engage, determine the real-world impact. By building on the foundation of policy basics, we can better understand the machinery of regulation and its role in shaping trustworthy, accountable AI. For practitioners, this next step bridges awareness with application, showing how to navigate complexity responsibly and with confidence. Thanks for tuning in to Bare Metal Cyber, your trusted source for cybersecurity educational materials, news, and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.